There's something funny going on.
There's something funny going on, going on. There's something funny. Yeah.
Hi everyone, my name is Paul. Thank you for joining me for this video number 6 in my series of videos with regards to my case against the City of Dearborn in front of Judge Eugene Hunt. In this video, I'm going to discuss two items that are going to play a major role in upcoming videos. First of all, I'm going to discuss motions, specifically going into details with regards to the timing of filing of motions, as well as the timing of service of motions on other parties. And second of all, I'm going to discuss a specific type of motion, a motion for more definite statement. Regarding timing of filing and serving motions, there are different types of motions and they can have different timings. For example, a motion to compel, which we've dealt with in previous videos, must be served at least 9 days before the time of the hearing if sent by mail. That can be reduced to 7 days if hand-delivered or by email if you have an agreement between the parties to allow service of documents via email and that these emails meet specific standards as set forth in the Michigan court rules. In my case, even though I did sometimes receive emails of documents from the city, there is no such agreement between us. As the motions from the city were sent via the mail, these types of motions had to be sent by mail at least 9 days before the date of the hearing. Another type of motion is a motion for summary judgment, or in Michigan, what's called a motion for summary disposition. An example of this type of motion would be asking the court to dismiss a case based on the pleadings already entered, as these pleadings may not meet legal requirements. The timing for service of this motion is 21 days before the hearing. A motion to request dismissal without prejudice must be made under this motion with the prescribed timing requirements that I just indicated. Now, how do you count the number of days before the hearing? There's a specific court rule that tells you how to count days. However, I simply went to the Michigan Court of Appeals website and used their time calculator. You enter the starting date, the number of days, and then it tells you the target date. To give you an example, as mentioned in my previous video, the next hearing date scheduled was for January the 18th. So, if I wanted to file a motion such as a motion to compel, and I wanted to place that motion on the docket for that hearing date, I would have had to serve it via mail on January the 9th or hand deliver it on January the 11th. However, if I wanted to get a motion for summary disposition heard on January the 18th, I would need to have served it 21 days prior to the hearing. That would mean a mailing date of no later than December the 28th. The second item I want to discuss here is a specific motion called a motion for more definite statement. This is discussed in Michigan Court Rules 2.115. This motion requests the judge to order the plaintiff to amend their complaint because it is so vague or ambiguous that it doesn't comply with the requirements for pleadings. There is a specific time frame for this defendant's motion. The defendant can only file it prior to having filed responsive pleadings. This makes obvious sense. If you are able to answer the plaintiff's complaint, then how can you argue that the complaint is vague or ambiguous? I actually had a hard time finding case law that deals with this situation where a defendant files this motion after having already filed their answers. Apparently, I would assume because it's not typical. But I'll put up this snippet here to show what I did find. The case is Belle Isle versus City of Detroit, and they are citing previous decision from the Court of Appeals, but I was not able to find their previous reference. Of course, being unrepresented, my research skills are poor and I don't pay for Westlaw. But here you see exactly what I just said. The motion for more definite statement cannot be filed after answers to the complaint have been filed. Now that we got those items out of the way, you may be wondering what they have to do with this case. As I mentioned in the last video, the next hearing date was January 18th. That was the next and last scheduled pretrial date. That date was fast approaching with no motions filed or on the docket. On January the 9th, I received a voicemail from Judge Hunt's office. In this voicemail, they were asking me to reschedule the hearing. I'll play that voicemail here.
This message is for Paul. My name is Dee, and I'm calling from Judge Hunt's office at the 19th District Court. If you could, please return my call. I have some questions about the court date that's scheduled for January 18th and possibly actually rescheduling that. The direct line here is 313-943-4223. Thank you.
Of course, when the judge's office calls you, you call back quickly, which is what I did. It turns out that William DeBiasi, the city attorney, had informed the judge's office that he was swamped and asked them to call me to reschedule. That's right. Instead of contacting me directly to reschedule or see what's available with me, he asked the judge's office to contact me to reschedule. Now, perhaps this is normal. If one party wants to reschedule, they contact the judge's office and ask the judge to contact the other party directly. Nevertheless, I found this odd for a few reasons. First of all, I did not realize that in essence, judges' secretaries would act as secretaries for the other party. Further to this, in order to reschedule a hearing date, they'd actually have to know what that party's calendar is like before scheduling it with me. Another issue is that this puts me in a rather unfortunate position where I'm actually being asked by a judge to reschedule a hearing rather than being asked by the opposing party. Who's going to say no to a judge when asked this question? Now, if I was William DeBiasi and I had this option available to me, I too would have taken advantage of it. It's very unlikely that someone would say no to a judge when asked to reschedule a hearing. But all these issues are minor in comparison to what happened next. So at this time, I've agreed with the judge to move the hearing date from January the 18th to January the 23rd. The following day, I get an email from William DeBiasi's office with 2 motions attached, saying that they will file these motions the next day and mail them to me. So much for Mr. DeBiasi apparently being swamped. Now, remember my discussions earlier regarding timing for motions? Let's look at these new motions in the context of the required timing I discussed earlier. Before rescheduling, the hearing had been set for January the 18th. Remember, any motion that does not involve asking for dismissal must be mailed at least 9 days prior to the hearing date, if served via mail. Let's look at the Court of Appeals time calculator as I walk you through this. I received the voicemail requesting the rescheduled hearing date on January the 9th. We'll input that as the start date. The number of days required for service by mail is 9 days for motions that are not motions to dismiss. We'll input that as the number of days. You click Calculate Target Date, and it provides you with January the 18th, the same date as the original hearing date. So, January 9th was an important date. William DeBiasi would have needed to prepare and mail his 2 motions to me on January the 9th for the 2 motions to be put on the docket for January the 18th. My point with all of this is that, in retrospect, what didn't seem right to me was that it seemed that William DeBiasi was only requesting a rescheduled hearing, not because he was swamped, as he had told the judge, but in order to file these motions and get them on the docket for the next hearing date. Therefore, his claim that he was swamped seems, to me and in hindsight, to have been disingenuous. The following day, he filed these motions, and it would seem that he got what he wanted. I realized later that it just didn't seem right. Oh, but it gets better. Remember I said earlier that any motion for dismissal without prejudice must meet the guidelines of 21 days notice prior to a hearing date? I'll put this information up here again. So, if William DeBiasi wants to file a motion to dismiss for that hearing date, he missed the deadline. While I'm assuming he doesn't want to have to wait for a future hearing date, as that could mean more potential issues with his case being brought up. For example, as mentioned in my last video, I'd point out to the judge Mr. DeBiasi's complete failure to respond to the interrogatories in the manner in which he assured the court he would do. Of course, that wouldn't have looked good for him. So he's going to want to get this motion dismissed in as quickly as possible on the next hearing date as scheduled if he can. So what does Mr. DeBiasi do? In my opinion, he uses a rather clever tactic in order to avoid the 21-day requirement for a motion to dismiss. First of all, he titles it a motion for more definite statement, not a motion for dismissal. If you think that I'm misleading the viewer here, with regards to William DeBiasi being tricky in his filing, I will lay out the facts about this in just a minute. Now remember, and I'll put this up here again, a motion for more definite statement is not a motion for dismissal. In fact, when you read the language of the court rules, it's obvious that the court only has one option here if they grant the motion: to give the party a chance to amend their pleadings to, in essence, make their pleadings clearer or in line with legal requirements. The Michigan court rules indicates the court must grant 14 days or such time as the court may set to make these changes, but again, it is only after providing this time to amend the pleading that the court has the right to strike the pleading. It's clear, the Michigan court rules does not give the court the opportunity to dismiss based on a motion for more definite statement. Now, back to William DeBiasi's specific motion and the facts. Look at it here. As previously stated, he titles it a motion for more definite statement. That's pretty clear here. But look at the brief and support section. He indicates it's a motion for more definite statement and a motion to dismiss. Look at the opening paragraph again, where he provides 3 rules that he's utilizing for this motion. Look again at the brief and support. He's added a 4th rule, which, you guessed it, represents the Michigan court rules that discusses motions to dismiss without prejudice. Now let's look at the body of this pleading. Look at count 7 here, where he adds, in addition, Michigan Court Rule 2.116C8 provides that a party may move for a dismissal of an action if the opposing party has failed to state a claim upon which relief can be granted. However, again, this was not a motion for dismissal. Had it been a motion for dismissal based on the Rule C8, as it's commonly referred to, he would have needed to provide me with 21 days notice. Of course, again, this wasn't titled a motion to dismiss, but he's playing the game here. There's several more, but to keep this short, I'll leave it with this one here. William DeBiasi's notice of hearing indicates that this was a motion for more definite statement and a motion to dismiss. Game over. As you can see, he's tried to, and it would seem has successfully, skirted the Michigan court rules regarding timing for motions to dismiss. I'm entitled to 21 days, and he and the court are not giving me anything near this. This, in fact, is a violation of my due process. I thought at the time that he was trying to pull a fast one on Judge Eugene Hunt by using these clever tactics. However, it seemed during the hearing that Judge Hunt didn't really care that much about these Michigan court rules. In fact, there are other violations of Michigan court rules by William DeBiasi that I will get to in the upcoming videos. The judge was all for dismissing this case despite these violations. Remember back to the phone call from the judge with regards to trying to reschedule the hearing date? At that time, I had not put together how rescheduling the hearing benefited William DeBiasi in this case. It was only later on when this became clear, when I noticed some odd decisions and comments from the judge during the hearings. Just like when Judge Hunt's office called me back then, it seemed that he was working for William DeBiasi. During the hearing, it seemed the same way. It was very, very weird. Finally, I want to remind the viewer of a specific court rule, Michigan Court Rule 2.114, that I mentioned previously in video number 3. When William DeBiasi and his co-counsel, Deborah Walling, signed this pleading and filed and served it, they certified that this motion was well grounded in fact and is warranted by existing law. William DeBiasi was admitted to the Michigan State Bar way back in 1983. Deborah Walling is corporation counsel for the City of Dearborn and was admitted to the State Bar back in 1984. With their many years of legal experience in filing pleadings, do you think that they don't know motion timing deadlines? Do you think that they don't know that a motion for more definite statement cannot be made after they've already answered the complaint? There's something funny going on here, and this is just the beginning. I hope you'll join me for my next video when I talk about the hearing. Thank you.